Michael Seme, Peter Kiplangat Elias Sungura, Neko Siteto Mopei. I believe Ms. Ngugi is there. Okay.
Yes.
Mr. Kiprotich. This is a ruling on an application dated the 22nd December 2025, brought by the Office of the ODPP, led by the Senior Prosecuting Counsel, Mr. Ishmael, through Sergeant Lucas Juma of Directorate of Criminal Investigation, Serious Crime Unit, seeking custodial orders to detain the three respondents for a period of 21 days at Nakuru Central Police Station. The application is premised on Articles 49, 24, 25 of the Constitution and Section 36 of the Criminal Procedure Code. The applicant contends that the respondents are under investigation for serious offenses, including murder, arson, promoting warlike activities, malicious damage to property, and unlawful possession of firearms allegedly committed during the violent clashes in Transmara South Sub-County between November and December 2025. The applicant asserts that the complexity of the investigation, the gravity of the offenses, the risk of interference with witnesses necessitate extended detention beyond the constitutional 24-hour limit. The application was opposed by the counsel for the respondent, who raised several grounds challenging its legality and necessity. The applicant's case. The application, as earlier stated, dated 22nd of December and supported by a sworn affidavit of Sergeant Lucas Juma, invokes the provisions that have indicated and seeks custodial order to hold the three respondents at Nakuru Police Station for 21 days. The applicant states in its investigation investigating grave offenses allegedly committed by the respondent, namely murder, contrary to Section 203, arson, warlike activities, possession of firearms, etc. According to the affidavit, the first and the second respondent were apprehended on the 20th of December, at Narok Town and Angata Barikoi respectively, while the third respondent was arrested on 21st December 2025. The arrest followed information gathered from the national government administrative officers, the local police command, residents of the affected areas, and official government sources linking the respondent to the alleged crimes. The alleged offenses are said to have occurred on diverse dates, that is on 22nd November 2025 and 22nd November 2025 and 20th December 2025 within Angata, Barikoi, and Lolgorian wards, Transmara South Sub-County. The applicant attributed these events to the death of 8 residents, numerous injuries, and the burning of over 100 houses and displacement of more than 200 families, including vulnerable persons such as women, the elderly, and the children. The applicant, particularly the reported fatalities, are as follows. There is Wesley Kiprotich, Bernard Kimeto, there is Philip Chirchir, there is Vincent Kipkoech, there's Isaac Kibet and Isaac Kiplangat, who are both shot in the chest and reported by the Kerikani police station. There's also Johanna Berngetuny, who were ambushed and fatally shot, and while traveling on a motor vehicle KDH 854 Toyota Probox at Sitet area, with his passengers sustaining serious gunshot wounds. In addition, the applicant reports the death of William Barmasai, allegedly killed and buried under unclear circumstances within Rotik area on 18th of December 2025, with the death not reported to authorities contrary to the law. In light of this, the applicant signals an intention to seek exhumation orders to facilitate the postmortem to determine the cause of death. The applicant contextualizes the violence within long-standing hostility between Syria, I don't know whether the right spell, Syria clan of the Maasai and the Kipsigis communities in Angata, Barikoi, and Lolgorian wards, attributing tension to historical land grievances, stock theft. Despite peace initiatives, including chaired by the Rift Valley Regional Commander, Mr. Abdi Hassan, on the 19th of December 2025 at Pefa Church in Lolgorian town, The applicant asserts the incitement has perpetuated the hostilities. On involvement, the applicant avers that the first respondent is the elected member of County Assembly of Lolgorian Ward and a member of Syria clan, allegedly using his public office to incite attacks against Kipsigis neighbors. The second respondent is described as a Kipsigis resident of Angata Barikoi, allegedly a militia member in possession of firearm used in attacks against Maasai residents. The third respondent is said to be an aspirant of the Lolgorian MCA seat who is allegedly inciting and financing kinsmen to perpetrate violence and destruction. A preliminary forensic observation, the applicant says, indicate that many fatalities and injuries were caused by gunshot wounds. Spent cartridges recovered at the murder scene in Sitet area are identified as 7.62 mm special, expended from an AK-47 rifle. The applicant treats this finding as indicative of the use of prohibited or unlawful possessed firearms in the commission of the offense. The investigation plan outlined by the applicant is extensive and multi-pronged. It includes revisiting, processing, and documenting multiple scenes of murder, arson, and stock theft across the two wards, tracing and recording statements from victims of arson, murder, assault, and stock theft, as well as from national government administration officers, local police, and other witnesses, and obtaining medical report, post-mortem, pith reform, treatment notes, and related documentation from facilities in Narok, Migori, Kisii, and Homa Bay counties where the victims and suspects were treated or bodies preserved. Further, planned steps involve tracing and recovering firearms used in the incident for forensics examination, subjecting the respondent electronic devices and social media accounts to digital forensic analysis, tracing and apprehending all perpetrators with a view to charge, obtain an execution order in respect of the late William Barmasai for postmortem, and obtaining and analyzing the financial records of the respondents. The applicant maintains that the scale and complexity of these investigation steps necessitate additional time beyond the constitutional 24-hour framework for presenting suspect to the court. It projects that a period of 21 days is required to complete the investigation and thereafter forward the file to the office of the DPP for perusal and charging. Risk factors are emphasized to justify custodial orders. The applicants claim that the respondent wields significant influence on the ground, and if released may interfere with witnesses or others, compromise the integrity of the investigation process. It also raises concern for the respondent's own safety, asserting that they are, in quotes, marked men who could be harmed by rival groups if released during an unstable period. Regarding the risk of absconding, the applicant singles out the second respondent, who is said to reside within 4 kilometers of Kenya-Tanzania border and is therefore portrayed as a flight risk should he be released at this juncture. The applicant further asserts that the respondent's physical presence will be required during critical investigation activities, including recovery of firearms, identification parade, and clarification arising from witnesses' interviews and forensic analysis. Further, the applicant argues that public interest dimension is paramount. It underscores that the matter involves multiple fatalities, serious bodily injuries, widespread arson leading to massive loss of property and displacement of more than 200 families, thereby elevating the case to one of a national concern, warranting judicial deference to investigative needs. On the legal threshold, the applicant contends that Article 24 and 49 of the Constitution permit a limited curtailment of liberty where demonstrable justifiable in an open and democratic society, particularly to safeguard investigation into capital and other serious offenses, and that Section 36 of the Criminal Procedure Code provides the procedural pathway of such custodial orders. The application prays that the court gives priority to the matter in view of its urgency, grants an order for 21 days detention of the respondent at Nakuru Police Station to facilitate the completion of enumerated investigation tasks and make any further orders necessary to preserve public order and the efficacy of the investigation, with no orders as to costs. The respondent's position. Counsel for the respondent mounted a strong opposition to the application, challenging both its form and substance. Ms. Bosibori, together with Ms. Ngugi, appeared for the first and second respondent and began by attacking the validity of the application, arguing that it was defective. They contend that the supporting affidavit sworn by the applicant was neither dated nor commissioned, contrary to Section 5 and 8 of the Oaths and Statutory Declaration Act. This they submitted rendered the application fatally flawed. On the merits, the counsel argued that there was no compelling reason to justify the continued detention. They argued the court to release the respondent on bond or bail, emphasizing that the first respondent is a member of county assembly and a respected leader in society, while the third respondent resides in Lolgorian and is not a flight risk. They stressed that both the respondents are family men with deep roots in the community, making absconding highly unlikely. Further, they submitted the respondent will not interfere with witness, noting that the applicant had not disclosed the identity of any of the alleged witnesses, of any witness allegedly at risk. They argued that the allegation of the interference was speculative and unsupported by evidence. They also highlighted the personal circumstances of the respondent, the first respondent being 57 years old and has 31 children who depend on him, while the third respondent similarly has several dependents. With schools about to open, they contend that the detention will jeopardize the welfare of these families. Medical concerns was also raised. The first respondent is said to be diabetic, and counsel informed the court that his condition deteriorated upon arrest, necessitating urgent medical intervention. They argued that prolonged detention would endanger his health and violate his right to dignity and life under the Constitution. Similarly, the second respondent was said to be living with disability and reliance on prosthesis requiring regular medical attention. The counsel invoked Article 49 of the Constitution, which guarantees the right to bail unless compelling reasons are shown, and Article 25, which protects fundamental rights from derogation. They argue that the applicant's reasons fell short of the constitutional threshold, and that any detention beyond arrest for purposes of investigation among engaged, given the fatalities and displacement reported. However, public interest cannot override constitutional rights without clear justification. As stated in the case of Jacob Matende, public interest must be balanced against individual rights, and the scales tilt in favor of liberty unless compelling reasons are shown. The applicant's reliance on the complexity of the investigation is noted, but complexity alone does not justify detention where less restrictive means exist. Reporting condition and bond terms can secure cooperation without resorting to custodial orders. This court is mindful of Article 50, Subarticle 2A, which guarantees the presumption of innocence. Detention for investigative convenience risks converting pretrial processes into punishment, which is constitutionally impermissible. The respondent counsel aptly argued that any detention beyond arrest for purposes of investigation amounts to an affront to liberty and the rule of law. In sum, while the offenses under investigation are serious and the situation in Transmara South is volatile, the applicant has not discharged the burden of demonstrating compelling reasons for continued detention. The grounds advanced are allegedly speculative and do not meet the threshold under Article 49, Article 1F, and Article 24. The investigative steps outlined can be undertaken while the respondents are out on bond, subject to condition that ensure their availability and cooperation. As stated in most of the jurisprudence and the authorities that I've just quoted, the courts have consistently affirmed that bail is a right, not a privilege, and denial must be justified by cogent evidence. In this case, the applicant's reasons fall short of that standard. The appropriate course is to uphold the respondent's constitutional rights while safeguarding the integrity of the investigation through reasonable condition. Having considered the application, the supporting affidavit, the position by the counsel for the respondent, the submissions made, and the applicable constitutional and statutory provisions, the court finds that the applicant has not demonstrated compelling reasons to warrant the continued detention of the respondent for 21 days as sought. The investigative steps outlined can be undertaken while the respondent are out on bond subject condition. Accordingly, the application is dismissed, and in the interest of justice, the court hereby orders as follows in order to allow the investigation to proceed. 1. The first, second, and the third respondent shall be released on bond of Kenya shillings 500,000 each with one surety of similar amount. In the alternative, a cash bail of Kenya shillings 200,000 each. If they opt for paying cash bail, they will provide each respondent will provide one contact person. Those contact persons shall act as surety. The second condition is that as a condition of their release, the respondent shall report to the DCI Serious Crimes Unit, I don't know where the officers are, every Wednesday until the end of January 2026. For avoidance of doubt, the last Wednesday will be 28th day of January 2026. They'll be at liberty to be accompanied by their respective counsels on each of such visits. And lastly, the respondent shall not interfere with witnesses or otherwise obstruct the ongoing investigation, and also deterred from issuing any public being that the MCS, any public incitement in that circumstance. Any breach of this condition shall result in the cancellation of bond and immediate arrest. The matter will be mentioned on the 4th. I believe 4th is 4th of February. Yes, duty court. I believe that's all.